Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibis, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. We're jumping right in because there has been some last-minute filings in Donna Adelson's trial. Charlie Adelson has filed a motion saying that he does not want Donna's current attorney and his former attorney, Daniel Rashbaum, or the other attorney on the case, Mr. Morris, to cross-examine him. And he's not waiving his Sixth Amendment right. Jury selection is supposed to start first thing in the morning. I think we got a little something to deal with before that begins. Don't know if this is going to delay the trial. I could tell you, I don't think the judge is going to be very happy at all. But let's read through, and I highly recommend you go check out STS Podcast. When this news broke earlier today, COE went live with a couple of attorneys I haven't watched yet. I'm sure they have a better way of explaining it, but I thought we would at least read through these filings tonight and see what tomorrow brings. So the first filing came down at 11:18 this morning from Charlie's appellate attorney. And it says, state witness Charles Adelson's notice that he is invoking his Sixth Amendment rights as to his former counsel, Daniel Rashbaum, and he does not waive the conflict of interest regarding his attorney-client communications with Mr. Rashbaum. Goes on to say, state witness Charles Adelson files this notice and alleges, number one, Mr. Adelson was previously charged in Leon County with first-degree murder, conspiracy to commit murder, and solicitation to commit murder. The case proceeded to trial, and Mr. Adelson was convicted as charged. At trial, Mr. Adelson was represented by Daniel Rashbaum, Esquire. Number two, Mr. Adelson's judgment is not final. His case is currently pending on direct appeal. Mr. Adelson is now represented by undersigned counsel. If I messed this name up, I'm sorry, but I think it's Michael Offerman and Laurel Cornell Niles. Number three, in the instant case, the state filed an amended answer to demand for discovery on July 11th, 2024. This document listed additional prosecution witnesses, one of whom was Mr. Adelson. And it says Charles Adelson, care of attorney Daniel Rashbaum. The state has issued a subpoena for trial for Mr. Adelson, and Mr. Adelson was transported from prison to the Leon County Jail on Friday, September 13th, 2024. Undersigned counsel Offerman was able to meet with Mr. Adelson at the jail on Saturday, September 14th, 2024. Number four, the trial in Mrs. Adelson's case is scheduled to begin the week of September 16th, 2024. Mr. Rashbaum is one of the defense attorneys who will be representing Mrs. Adelson during her upcoming trial. Number five, the Sixth Amendment to the United States Constitution states, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The essence of the Sixth Amendment right is privacy of communication with counsel. They cite United States versus Rosner. The attorney-client privilege is the oldest of the privileges for confidential communications known to the common law. There's another case cited, Upjohn versus United States. Its purpose is to encourage full and frank communication between attorneys and their clients and thereby promote broader public interest in the observance of law and administration of justice. Number six, Rule 4-1.9 of the rules regulating the Florida Bar, entitled Conflict of Interest, Former Client, states the following. A lawyer who has formally represented a client in a matter must not afterwards, A, represent another person in the same or a substantially related matter in which that person's interests are materially adverse to the interest of the former client unless the former client gives informed consent. B, use information relating to the representation to the disadvantage of the former client, except as these rules would permit or require with respect to a client or when information has become generally known, or C, reveal information relating to the representation except as these rules would permit or require with respect to a client. In Culker versus State, the Third District Court of Appeal explained an attorney's previous relationship with a client who has become a witness for the government and plans to testify against the attorney's current client presents a dilemma of divided loyalty. It would be improper for the attorney to use privileged communications from the former client in cross examination of that former client. The third district in Culker added that a trial court has an interest in conducting a fair trial by ensuring that defense counsel's cross examination of his past client, Kruger, does not compromise Kruger's privileged communications. Number 8. Thus, because number 1, Mr. Rashbaum previously represented Mr. Adelson. Number 2, Mr. Rashbaum currently represents Mrs. Adelson. Number 3, the state has subpoenaed Mr. Adelson as a witness for Mrs. Adelson's trial, signaling its intent to call Mr. Adelson as a witness during the trial. And number 4, if Mr. Adelson is called as a witness by the state during Mrs. Adelson's trial, Mr. Adelson would be subject to cross examination by Mr. Rashbaum, his former attorney. Mr. Adelson files this pleading formally invoking his Sixth Amendment right as to Mr. Rashbaum, his former trial counsel, and Mr. Adelson specifically asserts that he does not waive the conflict of interest regarding his attorney-client communications with Mr. Rashbaum. Number 9, further, unless there is a finding by the court that Mrs. Adelson's defense team constructed an ethical wall with regard to Mr. Rashbaum's knowledge and information gleaned from his prior representation of Mr. Adelson from the initiation of its representation of Mrs. Adelson in this same or substantially related matter, Mr. Adelson would assert that his privilege and the conflict of interest applies to the entire defense team in Mrs. Adelson's case. And Mr. Adelson should not be subject to cross examination by any member of the defense team who has been tainted by Mr. Rashbaum's knowledge and information. Wherefore, state witness Charles Adelson prays this court will protect his Sixth Amendment right to the privacy of communications with his trial counsel, Daniel Rashbaum, and in conformance with applicable rules regarding the Florida bar, preclude the defense team of Donna Sue Adelson from cross-examining him. Holy moly. So let's wait till the last minute to do this because you've known since July you were on the state's witness list. To me, it just screams strategy. Who knows? But I mean, come on. The night before jury selection starts, after you've been brought from South Dakota to Florida, you want to file this? All right, but let's read Donna's defense attorney's response to this. That came in at 11:59 a.m. It says, response to Charlie Adelson's motion seeking to preclude former counsel from cross-examination. Comes now the defendant, Donna Adelson, by and through the undersigned counsel and files this response to Charlie Adelson's motion seeking to preclude former counsel from cross-examination and would state as follows. Number 1, trial is presently scheduled to commence tomorrow, September 17th, 2024. Number 2, Charlie Adelson, through counsel, has filed a motion seeking to preclude former counsel Dan Rashbaum from cross-examining him if called as a witness in the present proceeding where Mr. Rashbaum represents Mr. Adelson's mother, Donna Adelson. Number 3, as the court is aware, the undersigned was brought into the instant case in January 2024. Number 4, while defense counsel believes that an ethical wall was created where Morris was not tainted or contaminated by information from Rashbaum, third-party counsel has been secured specifically for the purpose of examining Mr. Adelson, should the need arise. Communication with the third party attorney has been restricted to confirming his availability and a conflict check. Number 5, the undersigned has conferred with Mr. Offerman as well as Ms. Kappelman. The proposal appears to resolve Mr. Offerman's concern. Counsel does not believe Ms. Kappelman has an objection to the proposed remedy. Mrs. Adelson requests the entry of an order in accord with the solution proposed herein. Now, the last time I checked, I have not seen a response by the state about these motions, and I'll keep an eye on it, but I don't think we're going to see anything on the website tonight. It's almost 9 o'clock, but we'll see what happens in the morning. As you know, jury selection set to begin, I believe, at 9 a.m., which, by the way, as of right now, it's not clear whether or not jury selection will be live streamed. I talked to COE, Joel's wife from STS. She called the local station that was the pool camera for jury selection, and apparently they're not going to stream it. So we don't know if another network might pick that up and stream it. I'll stay on top of it. If it is streamed, I'll be live streaming it. But I don't think the judge is going to be very happy in the morning because they've had months to go through this and resolve this, and also to bring on a third party who, if that's going to be the case, how long will it take for this third party to get privy to the facts of this case to be able to effectively cross examine Charlie? It's a mess. Could it delay the trial? Sounds like it. Who knows? Everybody I've talked to in the legal field says that this is going to have to be remedied before they start jury selection. You don't want to have a jury that's already in place and then you've got this huge issue. So keep you guys posted. I'm not a legal analyst, so go watch STS where the two attorneys were on talking about this. I just wanted to read the motion and let you know what's going on. But I'll see you guys tomorrow. Hope you have a good rest of your evening.